Hello, welcome to today's immigration tidbit. Okay, well, applying for an immigrant visa or the green card, of course, is different than applying for a non immigrant or a temporary visa, whatever the basis happens to be. Now, you're on an R1, which is a religious visa, and it's for a temporary basis. Then, of course, you would have to go back to your home country. The I-360 is for the green card, and it is much more difficult to get an I-360 approved than to get the R1 approved. Unfortunately, a lot of people think, it's pretty much the same thing, and it's not. There are a lot more requirements. Now, given that, simply applying for the I-360 or what's known as the EB4 preference for the green card does not give you an automatic extension on the R1. It doesn't allow you to stay longer. It's not the same as a change of status. Now, I don't know how much longer you have on your R1, but if your R1 is about to expire, and by that token, meaning your R2s are about to expire, then you have to do either an extension or you have to do a change of status to something else as you are awaiting. Now, the problem further is that now that you have applied for the I-360, you have indicated your intent to remain here permanently as a lawful permanent resident, which completely goes against a lot of non-immigrant visas, including the R1. You would have to, of course, with the R1, prove you intend on going back to your home country, which, of course, is difficult to do now since you've applied for the I-360. There are other types of non-immigrant visas that don't care about if you've applied for the green card, such as the L1 or the H1B. But unless you have an employer willing to sponsor you and you qualify for those, that's not going to help. You do not want to go out of status while waiting for the I-360. That does two things. That assumes that you're going to get the I-360 approved, which is not a good assumption just because you're on the R1. And it assumes that you're going to get it approved sooner than later while the R1 is still valid. So if either of those are not the case, you will need to leave so you don't go out of status, don't accrue unlawful presence days, and are not then subject to a waiver, which is going to make everything more difficult. Additionally, on the R2s, if your kids who are on R2s are going to turn 21, they no longer qualify for R2 or as a derivative, and they may not qualify then to adjust status either, depending when and hopefully if the I-360 is approved. Okay.